Bonani, he is the best tutor in UNISA for LLB, PVL3702, which is the law of a contract. And we are here to solve all your problems easy and fast. Okay, so this is assignment for 2024, assignment number 1, and good luck for good luck with this module anyway. So the due date is 25 March 2024, which I believe it may be extended, and it must not exceed 2 pages. Okay, so let's go down. We must note down that we have to understand the case of Mereski versus Mogel and Pilar versus Sheikh. Okay, we have noted down those 2 cases, which we must understand. So here is the scenario and here is the problem which we must solve. Assignment number 1 question. So let's go and read this together so that we know what to do. Jack is a property developer who is well-known for building residential developments. He recently built cluster homes in an upmarket suburb in Cape Town. All the cluster homes are built with the same size and layout, and they only differ with the positioning of each cluster in the complex. So it's like RDPs. RDPs are in the same size and layout, but they are differ with the positioning, right? This development is a brand new, and Jack appoints Sandy as his estate agent to market the sale of the cluster homes. Let's highlight this one with a green to show that Jack has given a green light to Sandy to act on his behalf. So now we have a Sandy who's acting on behalf of a Jack to market the sale of the cluster homes. Okay, Sandy shows Gloria a beautiful cluster home in the complex. Remember, Sandy is the rightful person to market the sale of the cluster home. This must be noted down. And then she shows Gloria a beautiful cluster home in the complex, which is next to the guardhouse at the entrance of the complex. So let's note down at the guardhouse at the entrance. So let's note this one down. Let's put it in a yellow. So Sandy is showing Gloria, saying, "Look, Gloria, look at that cluster home, which is next to the guardhouse at the entrance." And then Gloria immediately falls in love with the cluster home. And in a few days, she signs the offer to purchase the document presented to her by Sandy. Okay, let's come here. She signs the offer. So she signs. She signs. Let's give it a green light. So she signs. So she was given a green. She's given an obligation now. And no problem. Oh, I'm loving that house, which is next to the guardhouse. Yo, I'm loving it. So let me sign the offer. Okay, it's between Sandy and Gloria, and of course Sandy has been appointed by Jack, who completed all the relevant details on the document relating to the description of the property. So Sandy is the one who completed all the relevant details on the document relating to the description of the property. Remember, Sandy is the one that shows Gloria the house next to the guardhouse, and then she also completed all the relevant details on the document relating to the description of the house. The document is later also signed by Jack as the seller. So Jack signed. Okay, let's note this one. Jack signed. Let's note this one. Jack signed the document. However, it subsequently turns out that the cluster home referred to in the signed document is not the one that Gloria viewed and fell in love with. Now we have a problem. The cluster home referred to in the signed document is not the one that Gloria viewed and fell in love with. The one she signed for and the one she viewed are different properties. Let's note this one down. Now we have a problem. It's a different property. Let's put down in a pink. Now she signed for a different property. While she's thinking that she's signing for the cluster home, which is next to the guardhouse at the entrance. In fact, the cluster home she signed for is right at the back of the complex. Let's put this one right at the back of the complex. Now it means that she has signed for different properties and she has signed for cluster home, which is right at the back of the complex, which now is a different story. Let's go on. Which is not in the best position in the complex. Jack is of the view that a legal binding contract was concluded with Gloria. Jack is of the view. So this guy believes that the legal contract has been concluded because Gloria signed and assigned. So there's a legal obligation. So yeah, I believe that the legal binding contract has been concluded in accordance with the written signed document for the cluster home described in this document. Gloria approaches you for legal advice as she thought that she was signing for the cluster home that was next to the guardhouse at the entrance of the complex. Apply the will theory. So we are going to apply the will theory. Will theory. Let's put down red and instuas iro doctrine. Instuas iro doctrine. Let's put it in red. So we are in this scenario we have to apply the will theory and we have to apply the instuas iro doctrine to advise Gloria whether she concluded a legal binding contract with Jack or not, based on the written document that they both signed for the cluster home described in this document. Discuss fully referring to the relevant cases of law, and you must never apply CPA. That is what always happens. You must never apply CPA. So let's deal with the scenario. So now we have read the scenario, we have understood the scenario. Now let's deal with this question and answer the question. Firstly, I will look at this on the prescribed book, which is a law of a contract, third edition, which I hope most of you have it. It's very much important to read the definition of a contract first. Okay, they said a contract may be defined as an agreement entered into by two or more persons with the intention of creating a legal obligation or obligations. Okay, it means that an agreement is very important to create a legal obligation. If we apply that definition of a contract here, we can see here there's a Jack here who signed the document. We can see that there's a Gloria who signed the document, and the document is about the selling of a cluster home, which is marketed by Sandy, but the person who's selling it is Jack, selling to Gloria. So in that definition of a contract, you can see that there is an agreement that was concluded to create a legal obligation by Gloria and Jack. Okay. Now we'll go straight to look at the requirements for a valid contract, and we'll go straight to the consensus. It says that the minds of the parties must meet on all material aspects of their agreement. Let me repeat. The minds of the parties must meet on all material aspects of their agreement. Then let's go and look if the minds of their parties are meeting on all material aspects of their agreement. Now we are coming back to apply that consensus and see if all materials of the agreements are meeting. Let's see. Okay, then Gloria is looking for a cluster home. and Jack is selling the cluster home. They have all the same mind. Okay? Now, the problem is that Gloria is looking for a cluster home which is next to the guardhouse at the entrance. And then Jack is selling the different properties which is at the right back of the complex. Now, it means that their minds are not meeting all the material aspects of agreement. Let me repeat. The minds of these two parties are not meeting the material aspects of agreement. This one is looking for the cluster home. Gloria is looking for the cluster home next to the guardhouse at the entrance, and this one is looking for the selling the one that is right at the back of the complex. Remember, we are dealing with consensus now to find whether there is a consensus between Jack and Gloria. So now we have to read 3.2.1, which is about the unliteral, mutual, and common mistake. They said that unliteral mistake occurs where only one party is mistaken, while the other party is aware of his or her mistake. Mutual mistake refers to the instance where both parties are mistaken about each other's intention and are at cross purposes. So those were different between unliteral mistake and mutual mistake, which you have to take into account. And they gave a scenario here, say that suppose that A agrees to purchase B's property, A erroneously mistakes another property for B's property, while in fact B's property is situated further down the road. If B is unaware of A's misapprehension, B mistakenly believes there is consensus, and the case is therefore one of mutual mistake. But if B is aware of A's mistake, it is a case of unliteral mistake. Both scenarios, however, are cases of dissenters, and the distinction therefore has legal importance. So because as a result of that, we have to go straight to look at the will theory straight. Before we discuss the will theory, we must also note down that there is a common mistake that is shared by parties and differ fundamental from unliteral and mutual mistake, because it does not lead to dissenter. Now, unless it results in a contract being a void as it rests on a common underlying supposition that is later revealed to be incorrect. So this one common mistake, we are going to also look at it. That's why I'm reading this one, so that you understand when we deal with that scenario. We are going to deal with the cases of a common mistake so that you understand when we go up. Now, it's very much for us, before we start with the will theory, to read this one. This one is about the will theory. It says that if we accept that actual agreement is the primary basis of a contractual liability in accordance with the will theory. So, according to the will theory, actual agreement is the primary basis. Then the first question that arises when determining the existence of valid contract is whether the parties in fact reached consensus ad adam, which is the first primary basis of contractual liability under will theory. On the basis of the will theory, if the consensus is reached and provided the other requirements for a valid contract are met, a legal binding contract arises. However, if the parties are not in agreement, then no contract will exist on the basis of the will theory. In such circumstances, unless the contract can stand on the secondary basis of reliance, it will be void ab initio. So now we have read about the will theory, but I'm going to give you more information about the will theories and the cases that are under the will theories, so that it will be easier for you to apply the will theory before we go to in Stewart's Error doctrine. I have summarized the will theory for you so that you understand, right? So I summarize like this so that you understand and you go and get more information if you want more information. To determine whether the contract comes into being is through consensus, which is talking about the will theory. The requirements of consensus are that the party must be intending seriously to contract. The parties must be of one mind as to the material aspects of the proposed agreement. The parties must be conscious of the fact that their minds have met. From these requirements, it is evidently that the parties were not contractual to the same agreement. Gloria thought she was contracting for a house at the guardhouse of the complex, while Jack was intending to contract for different property. This means that there is a dissensus rather than consensus. This gives rise to material mistake as determined by will theory. Some of the cases of material mistake are as follows. Then I gave case of George versus I gave a case of George. Let me highlight with a green. I gave a case of a George versus payment, which you have to go and look for more information. In this case, the plaintiff, without reading the hotel register, just signed it. The register contained a term excluding the respondent from liability for certain acts. The appellant was unaware of this term. The court held that there was material mistake based on performance. Based on performance. Let me highlight this one because it's very much important. Based on the performance. So here the material mistake was based on the performance. I gave another case which you have to go to look for, and that case is a very common case in the law. It's the case of Alien 16 Sterling Investments, Alien Visa 16 Sterling Investment. This is the common case. In this case, the plaintiff was intending to purchase the property pointed out to him by the seller's agent, which is the same as that one that Sandy pointed out. While the written contract that he signed indicated the different property, his mistake related to performance was material. Okay, this is the will theory, guys. Let me put down this one. That his mistake related to performance was material. Okay. In this case, the mistake is not related to performance only, but also the persona set up in the case of Koch vs. Op. Let me highlight this persona, and I will explain more about persona when we are doing part 2. Now, there was a performance which was material, and it was not just a performance only, but also the persona set up in the case of Koch versus Osborne, which I have indicated to you. And I think that the way I indicated here, you will able to go and search for these cases. Koch versus Osborne 1993 essay. That's when the persona was set up. Go and look for more information. A party can escape contractual liability based on indirect approach. Okay? It's another thing that I indicated to you as a solution. Firstly, mistake must be proven that it is both material and reasonable. I have already proven that it is based on mistake. To establish the reasonable of mistake is to look at the requirement. A material mistake is reasonable when mistake is based on misinterpretation. If the contract denier is not to blame for the mistake, if the contract denier did not cause a reasonable belief in the contract asserter that the contract denier asserted to the agreement. So with this summary that I've given, I hope that I shed a light to you. And you have to watch part 2, which will be dealing with Onsta's error doctrine. Remember, we have not finished to answer the scenario. We were just giving you some light and some cases which you'll be looking for in order for us to answer that scenario. And here I was talking about the will theory. And then I will give you more information about the will theories and the journal articles based on will theories when we are doing with part 2. And then part 3 will be concluding the contract. Thanks for watching part 1, guys. And watch for part 2, because if you just watch part 1 without part 2, you may able not to answer correct on the scenario. So now we have read, we have understood will theory, but we are still going to shed the light about more in terms of the will theory. Thank you guys for watching, and wait for part 2.